Here is the asterisk line-by-line rewrite in simple, clear English, made easy enough for a asterisk 5th grade student, asterisk, while keeping the asterisk same tone, same format, same length, same order, and asterisk no information added or removed, asterisk, grammar, spelling, and punctuation are corrected. CTAs are kept asterisk without any channel name, no extra lines added. Here's what they are not showing you. A forgotten microphone, a conversation that was never meant to be heard, and a judge who stopped an entire trial the moment he realized what was happening. Judge Caldwell did not raise his voice. He did not slam a gavel. He did something far more frightening. He went completely silent. Then he ordered the U.S. Marshals to seize the defense laptop right there in front of the jury, in front of the cameras, and in front of the defense attorneys who suddenly looked like they had just seen their entire careers flash before their eyes. What was on that laptop? What was in that recording? And why is everyone involved suddenly refusing to talk? I have watched the footage 17 times, and every time I watch it, I notice something new. So what pushed Judge Caldwell over the edge? One moment, one decision, one line the defense team should never have crossed. A microphone left on during a recess picked up a conversation between the lead defense attorney and someone who should not have been talking to them at all. But here's the thing. This was not random. This was weeks of suspicious behavior finally catching up. And I am going to show you exactly how it all fell apart. The case itself was already explosive. A high-profile fraud trial, millions of dollars. Powerful people with everything to lose. The kind of case that either makes careers or destroys them. Judge Caldwell had been overseeing this trial for 3 months. 3 months of motions, objections, and a defense team that seemed just a little too confident, just a little too prepared for every move the prosecution made. Everyone noticed. Nobody could prove anything. Until that microphone stayed on. Until that conversation was recorded. Until Judge Caldwell heard something that made him stop everything. The moment everyone is talking about is coming. But first you need to understand what the defense thought they were getting away with. Because when you see the full picture, you will understand why Judge Caldwell did what he did. Here is what actually happened, the moment everyone clicked to see. Tuesday morning, 10:47 a.m., courtroom 4B of the federal courthouse, the kind of room where careers end and legacies are made. Judge Caldwell had called a 15-minute recess a normal procedure. The jury left the room. The prosecution gathered their notes, and the defense team huddled in the corner of the courtroom, speaking quietly, assuming what everyone assumes during a break, that no one was listening. They were wrong. The courtroom's audio system, installed for ADA compliance and record-keeping, has microphones throughout the room. During active sessions, only certain areas are live. During recess, the system is supposed to shut off, supposed to. A technical glitch, or maybe something else, kept the defense table microphone active, and it recorded everything. The lead defense attorney spoke in a low voice. He confirmed the witness changed her story. We have the new version. They don't know she talked to us. Then another voice spoke, unidentified at first, but clearly not part of a legal team. She's scared. She'll say what we told her to say. Just make sure the judge doesn't find out about the contact. The conversation continued for 2 more minutes. References to adjusted testimony, mentions of an arrangement, and one chilling sentence that made Judge Caldwell's blood run cold. Caldwell won't know until it's too late. The audio was being monitored in the clerk's office, following standard security rules. Within 60 seconds, the recording was sent to Judge Caldwell's chambers. He listened once, then he walked back into the courtroom. Witnesses say his face showed no emotion, no anger, no shock, just a calm that felt terrifying. He did not speak to the jury. He did not speak to the prosecution. He looked straight at the defense table. "Mr. Harrison," he said, his voice flat, "please remain seated." The lead defense attorney started to stand. He started to object. I said, "Remain seated." That is when the marshals moved, not toward the attorney, toward the laptop sitting open on the defense table. "Your Honor, this is outrageous," Harrison began. "What is outrageous?" Judge Caldwell interrupted. "Is what I just heard on the courtroom audio feed. The laptop is being seized as evidence. Your entire team is ordered to surrender all electronic devices." The courtroom erupted. The jury was rushed out. The prosecution sat frozen, clearly not knowing what was happening. And the defense team, 3 attorneys, and 2 paralegals, watched as everything they brought into that courtroom was sealed, tagged, and taken away. But here is what nobody expected. Judge Caldwell was not finished. This trial is suspended pending investigation. Mr. Harrison, you are ordered to remain in this jurisdiction. All defense counsel are barred from contacting the defendant, the witnesses, or each other until further notice. Harrison's face turned white, truly white, the kind of pallor that comes from realizing your entire career just collapsed in 90 seconds. Your Honor, our client has rights. Your client's rights are not the issue. Counselor, your conduct is. Then Judge Caldwell said something that made every lawyer in that courthouse sit up straight. Federal marshals will escort you to processing. You are not under arrest yet, but obstruction of justice, witness tampering, and conspiracy charges are being evaluated right now. The courtroom went completely silent because everyone understood what had just happened. A federal judge had just caught defense attorneys allegedly coordinating testimony with a witness on tape inside his courtroom, and he responded with the legal version of a nuclear strike. If you are watching this thinking, finally someone is telling the full story, hit subscribe. I am going deep into this case because what I am about to reveal next about those defense attorneys is something nobody else is connecting. But not everyone agrees. Defense advocacy groups say this was a dangerous abuse of power. And honestly, when you hear their argument, you might understand why some people are concerned. The National Association of Criminal Defense Lawyers released a statement within hours. The seizure of protected attorney-client materials without proper warrant procedures sets a terrifying precedent. Judge Caldwell may have acted on emotion rather than law. One well-known civil liberties attorney explained it this way. Think about what happened here. A judge heard something he did not like during a private conversation and immediately seized property. What about the Fourth Amendment? What about attorney-client privilege? These protections exist for a reason. Social media exploded with divided opinions. Some called the judge a hero. Others called him a tyrant. Legal Twitter has been fighting nonstop for 48 hours. And here is the uncomfortable truth. There are real questions about how this was handled. Was the recording legal? The defense table was not supposed to be monitored during recess. Is that audio even allowed as evidence? Did Judge Caldwell have the authority to seize the laptop without a warrant? Experts are deeply divided. And what about the unidentified voice on the recording? If it was not witness tampering, if it was something else, did Judge Caldwell destroy an innocent defense team's ability to represent their client? Judges are not prosecutors, one critic said on cable news. He heard something, assumed the worst, and acted as judge, jury, and executioner. That is not justice. That is a judge acting like a vigilante. So who is right? Is Judge Caldwell a hero who caught corruption in real time? Or did he show what happens when emotion replaces procedure? That is the question no one wants to answer. And the deeper you look, the messier it becomes. But this did not come out of nowhere. Weeks before this explosion, the warning signs were everywhere. It started with a witness, Maria Delgado, a former accountant for the defendant. She was scheduled to testify about falsified financial records. Her original testimony crushed the defense. Clear, detailed, damaging. Then something changed. 3 weeks before trial, Delgado's attorney contacted prosecutors with a revised statement. Suddenly, the numbers she was sure about became unclear. Documents she confirmed were now possibly misremembered. Her solid testimony turned into sand. The prosecution raised red flags immediately. They told Judge Caldwell something felt wrong. Did the defense cross a line? They could not prove it. I expressed my concerns directly, the lead prosecutor wrote. The court acknowledged the concern, but said there was not enough evidence to act. Judge Caldwell's hands were tied. Suspicion is not proof. The defense had the right to be assumed legitimate, but everyone noticed. The defense cross-examinations were too perfect. Their objections came before prosecution moves. Their witness preparation seemed almost supernatural. Every week, they appeared to know what was coming. Judge Caldwell reportedly told his clerk, "Something is wrong. I can feel it, but I cannot act on feelings," until he no longer had to rely on feelings. That forgotten microphone gave him what he had been waiting for: evidence, real evidence, recorded evidence, evidence that did not require guessing. The stage was set. The defense had pushed their luck for months. They never imagined one technical glitch would end everything. Judge Caldwell had been watching, waiting, knowing something was wrong. And when proof finally landed in his hands, he acted without hesitation. Drop a like if you see where this is going. Because the seizure was just the beginning. What happened in the next 48 hours is where the story turns insane. And then it happened. The marshals moved toward the defense table. 3 of them, moving with purpose. This was not a request. Harrison stood. His hand reached for the laptop. Don't. One word from Judge Caldwell. One word that froze Harrison in place. The lead marshal, a 20-year veteran named Patterson, stepped between Harrison and the table. Gloves on. Evidence bags ready. This is protected material, Harrison said. Not anymore, Judge Caldwell replied. Privilege does not cover ongoing criminal activity. You know that. The laptop was sealed, then the phones, then the tablets, then the external drives. 5 legal professionals stood there, watching their case, their files, their communications, and their careers leave the room in clear plastic bags. 45 seconds. That is all it took. But while everyone focused on the seizure, they missed something critical. Judge Caldwell had already made a phone call during the recess. After hearing the recording, he contacted the U.S. Attorney's Office directly. By the time the devices were sealed, investigators were already on the way. This was not an emotional reaction. Judge Caldwell had suspected wrongdoing for weeks. The moment he had proof, he acted on a plan. The seizure was public, impossible to hide. But the investigation had already begun. He preserved the recording properly, prepared the legal grounds for emergency seizure under the crime-fraud exception. This was not overreach. This was strategy. And the defense walked straight into it. Do not go anywhere. What I reveal next changes everything. Drop a comment. Do you think Judge Caldwell was right? Even seasoned legal professionals say this is unprecedented. A former federal prosecutor explained it clearly. In my entire career, I have never seen a judge move this fast on witness tampering. Judges usually move slowly. Caldwell moved like a prosecutor, and legally, he may be right. In simple terms, he did not just react, he anticipated. He had built the case in his mind for weeks, and when proof appeared, he knew what to do. Behind closed doors, legal analysts are whispering one thing. The crime-fraud exception is real. If legal communication is used to commit a crime, privilege disappears. Caldwell believes he caught them in the act. If he is right, everything on those devices is fair game. Even defense attorneys admit this is serious. I defend people for a living, one said. But if that recording is accurate, those attorneys were not defending anyone. They were obstructing justice. The real debate is this. Did Judge Caldwell have enough proof at that moment? Was the recording clear evidence of a crime, or just troubling language that could be explained? This will be argued for years. Every piece of evidence will be challenged. Defense attorneys across the country are watching closely. Judge Caldwell has bet his entire career on this decision. If he is right, he is a hero. If he is wrong, his legacy is ruined. Smash the like button if this shows how complex this really is, because the impact goes far beyond one case. So what does this mean for you? Right now, defense attorneys nationwide are reviewing procedures. If one microphone can capture private talks, what else is recorded? Courthouses are checking their audio systems. This affects anyone who may ever need a lawyer. Are your private conversations truly private? After this case, nobody is sure. Expect motions, delays, and appeals across the country. The ripple effects have already begun. If you care about justice and privacy, this case matters. It may become the most important precedent of the decade. But here's what worries me most. If this seizure stands, judges everywhere have a roadmap. Wait for a mistake. Catch it on audio. Seize everything. On one side, accountability. Corrupt lawyers should be stopped. On the other side, what if a judge is wrong? What if a conversation is misunderstood? What if a defendant loses their legal team unfairly? And here's what nobody wants to say. What if the defense team is innocent? What if the conversation was taken out of context? What if adjusted testimony meant legal preparation? What if the arrangement was a fee discussion? What if Judge Caldwell heard what he expected to hear? Right now, careers are destroyed. A trial is frozen. A defendant is stuck in legal limbo. There is no undo button. The attorneys cannot forget being marched out. The defendant cannot undo months in custody. The judge cannot undo a decision seen worldwide. That is what happens when justice moves on instinct. And then the defense made it worse. Instead of staying quiet, Harrison held a press conference. A huge mistake. Judge Caldwell has engaged in judicial tyranny, he said, his voice shaking with anger. He violated our rights. We will take this to the Supreme Court. The backlash was immediate. Legal experts called it the worst move possible. One said it was like pouring gasoline on a fire. Then it got dangerous. Supporters showed up at the courthouse. Signs, chants, online threats appeared. Judge Caldwell's home address was shared, his family was harassed, threats escalated. The U.S. Marshals assigned protection. His family was moved to a secret location, all because Harrison spoke. This is witness tampering on a larger scale, a former prosecutor said. The same tactics, bigger audience. The defendant's family released a statement. They accused the judge of abuse of power. Security at the courthouse increased. Judge Caldwell has not spoken publicly since. Not once, which says everything. But here's what bothers me. Why was the microphone still on? The system has been there for 12 years. This has never happened before. Who was the unidentified voice? Why did the defense behavior change exactly 3 weeks before trial? Sources say forensic analysis is revealing major irregularities. The FBI's public corruption unit is leading the investigation. That is not normal. That suggests something bigger. The defendant has political ties, powerful connections. Judge Caldwell knew this case was dangerous. What if the defense was protecting someone else? Something is building, and when it breaks, it will not just be lawyers who fall. Subscribe now. Turn on notifications. The story is moving fast. Here's where things stand. The trial is suspended. The defendant is in custody. Bail revoked. 3 defense attorneys suspended. Their firm shut down. Devices are with the FBI. Analysis ongoing. But here's what is not public. Sources say the recording is over 6 minutes long. Only parts have been revealed. Judge Caldwell filed to seal the full audio. National investigations. That word matters. The next hearing is in 3 weeks. Everything depends on what is on those devices. The clock is ticking. Judge Caldwell is under 24-hour protection. His family is hidden. His courtroom is locked down. Is he a hero or part of something bigger? There are rumors the glitch was not an accident. Rumors of warnings from inside the courthouse. And the unidentified voice? It may belong to someone in federal law enforcement, not outside, inside. Is this corruption or a trap inside a trap? I do not know yet, but I know this. What comes next will be bigger than anyone expects. The question is, will you be watching when it happens?